passing literally on my way over here. I don't have a written request. I have not read all my email because I've been on the bench this morning. Do you want to make a record with regards to the media request from the state?
No, Your Honor.
Okay, from the defense?
No.
Okay. I don't see anyone here. I thought we would address it on the record, but I don't see anyone present from the media. Okay, I assume there's no objection if they come in. Ms. Kay?
No, Your Honor.
Ms. Daybell?
I always object to them, yes.
Oh, you object to them?
Always.
Okay. Is there anything you wanted to put on the record?
No.
All right. My thought is if they come in, we can address it. All right. The court's, this is the oral argument on Ms. Daybell's motion for change of judge for cause. The court's in receipt of and has reviewed motion to disqualify judge. This was filed on May 20th, and the state's response to defendant's motion to disqualify judge. Ms. Daybell, I've read your motion. In summary, the way I read it, you're asking for the court to remove Judge Boreski for cause under Rule 10.1. You cite several reasons, specifically that he's denied various motions. You mentioned facial expressions. You mentioned a belt and his not allowing you to remove it. You assert that he violated your speedy trial. There's a mention of religious persecution and an allegation of personal bias. So you're going to get, and then the state's response is that simply that the defendant does not establish judicial bias, appearance of bias, or fundamental error. Of course, under Rule 10.1, the court is evaluating whether or not Judge Boreski can be fair and impartial and whether he can conduct a fair and impartial trial in this matter. So I'm aware of the allegations. You'll have the opportunity to go first, then I'll allow the state and to address the court, and then you'll have the last word. Whenever you're ready, Ms. Daybell.
All right, guys, so here we go. Lori Vallow Daybell is now trying to get rid of the Judge Boreski. If she looks like she's having a good time, she is. So this is something we've seen her do throughout her life, is cause problems and chaos in the court when things don't go her way. Lori likes to destroy lives. This is something you've seen her do in courtrooms like with Joe Ryan. In other courtrooms where she's caused trouble with people's families, including Charles Vallow's family. What I've learned, and this is my opinion, that Lori Vallow is a wrecking ball. The reason for her existence is to destroy, destroy, destroy. If she isn't busy destroying something, she's pointing fingers and being a victim, victim, victim. So we've not quite figured out, does she truly believe the nonsense she's spilling out? Maybe, but not likely. I mean, she's like an expert manipulator. And usual, when she has control of her life and the world surrounding it, when she's not behind bars, it's her way or the highway. She cuts them off. And if cutting them off's not good enough, then she takes their lives. Now, if you pay attention here, you'll see a totally different tone in Lori's voice. She's trying to make this judge feel like she thinks that she's connected to her. This is something she likes to do. She likes to make people feel as if she's connected. But it's a connection that is just a manipulation key. It's not something she actually feels is true. Lori's recent past court appearances have been quite interesting, to say the least. She spent the majority of her time talking over the judge and arguing with the judge. She seems to believe that her points are very valid and correct. She doesn't understand why the courtroom isn't accepting that notion, at least in her head. What she wants is to make these excuses, to have these arguments. She's mad because she's not getting her way with the headset. She's arguing about headsets in the courtroom. And then the belt that she has to wear. She just wants to argue. And this is what the judge has tried to tell her. You know, if you had a legitimate argument, maybe we can consider taking it seriously. One of her main upsets is the fact that he denies most of her motions. All right, let's go ahead and watch Lori and this judge interact.
Okay.
I did file this motion in
Ma'am, I'm
this.
sorry, can you pull the microphone so I can hear you?
Sorry. I did file this motion in this affidavit after several attempts to. I made an oral motion with Judge Bresky and asked him to recuse himself because of the bias and prejudice that I had seen during our last trial and throughout the whole entire time that he has been the judge over all of these cases. And he refused to do so. So I thought I needed to put it in writing and put all my points in that I felt like were causing him to be biased and prejudiced against me, and that obviously you've read it, so you've seen all the different things that I put. There was an actual comment during trial when I was cross-examining one of the witnesses where he said to me directly after an objection from this state that I was comparing myself to biblical prophets, which I absolutely was not doing, and I didn't even realize it until someone showed it to me on the FTR afterwards that he had even said that, because I was in the middle of questioning the witness. And so there's several times that he made comments directly to me. I tried to address this with him directly in our last hearing on May 14th, where I asked him why he had denied every single motion that I had ever filed in the last year and a half, and he said that my motions had no merit. I asked him if my prior defense team, that he denied all of their motions, that they had no merit as well. And then I asked him, my prior defense team before that, all the motions they filed were denied, and did they have no merit at all either? And I asked him again if he would recuse himself from this case so that I could get a judge that was impartial and fair and have a fair trial. That is my right, my 6th Amendment right and my 14th Amendment right to have a fair trial, an impartial trial, and not a judge who has some kind of bias against me.
All right, anything else?
This was interesting. So when the judge says, is there anything else? Well, you can see that Lori's demeanor begins to change. She realizes at that time that she's not being respected in the way she believes that she needs to be respected, when in reality, it's just Lori throwing Lori's fits to get what Lori wants.
Has some kind of bias against me.
All right, anything else? Thank you.
Judge, just the prior defense motions almost all exclusively dealt with motions to preclude the media. Judge Boreski applied the appropriate law in finding that the media had a right to be present and tried to limit it by saying things like they couldn't focus on the defendant's papers or things like that to mitigate any of the concerns by the defendant. All of the defendant's motions that she has filed have been without legal basis. They've been appropriately ruled on, and the state's motions that the state has won have been ruled on based upon, again, legal basis. So the fact, as the court is well aware, that the defendant has had all of the motions ruled against has no basis for bias if they're all been ruled on based upon the rules of law and the rules of evidence. So we see nothing that the defendant has provided here that would rise to a level to preclude or recuse Judge Bresky from this case.
Thank you. Ms. Daybell, you can have the last word.
Yes, also, along those lines, Your Honor, that's one thing that I asked Judge Boreski, is that he has denied all these motions with no finding of fact and no conclusion of law. I said, what is the finding of fact and conclusion of law? These are just denied, 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 denied. He's also denied several attempts for me to try to ask the state for discovery that he's just denied outright. And then as I keep filing more and more, as I find out what we don't have and I ask for it, I'm continually, even to last week, getting brand new discovery with brand new Bates numbers, stuff that they realized they never even had before that hadn't been turned over. And I've been asking Judge Boreski for these items for a year and a half. And I'm getting them 1 week before trial. We start picking our jury today. We're supposed to be doing our strikes today. And along those lines, I had this motion about the REC belt that I had asked him about since we went through this whole trial, and there was times when the belt didn't fit around me, so it fell out of my clothing. We had to stop trial and I had to go fix it. And that is what MCSO recommended, that if that was too burdensome, that they would put an armed guard in the back. And because of the media that Judge Boreski has let into every single one of the hearings and the trial, that they already have an armed guard back there. So it wasn't going to cost the state any more money. It wasn't going to cost anything if he just had them remove the belt and went over the security that the MCSO actually recommended. Every single thing that I asked for has been denied. I feel like he does have a personal bias against me, and all I'm asking for, I went through a whole trial with him, even thinking he was biased against me before the trial started. I filed for a new motion because it came to our attention through the media. The media sent Judge Boreski a clip of one of the jurors saying that he found out about my prior convictions beforehand, before his deliberations. And this is the same exact juror who was brought in twice during trial by Judge Boreski, where he had to admonish him for, one, being on his phone, and two, talking to one of the other jurors about the case. And now he's saying, well, he went on another media thing and said that he took it back. He took back what he said, so I'm not going to give you a new trial, and nothing was done about it. He refused to call them in and have a hearing and put him on the stand under oath and ask him if he found out this information prior to deliberations. It was very confusing, and everything is just outright denied. I want to go to trial. I want to have a fair trial, as fair as possible. I don't feel like I can do that with Judge Boreski, and I would like to be appointed a new judge who wouldn't know anything about the case and be fair and as impartial as possible. Thank you.
So what Lori's wanting to do is pretend she's not this incarcerated murderer of her own children, Tammy Daybell and Charles Vallow. In my opinion, it's just a game for her. She knows most likely she has no chance of winning in court. Maybe she does if she can get her way. You know? If she can get everyone to know nothing about her past, she might can win. And that's kind of weird, the fact that she doesn't seem to care about all those lives that she's taken. She continues to show lack of remorse, zero concern for these horrific acts. It's all about her getting her way and making things look the way she wants them to look. Something she's been good at her entire life. But interestingly, what really strikes me odd is knowing that chaos that she can create. Where are some of these people that have run into her over the 10 years or 13 years that she's with Charles Vallow? There's no one. It's like it's been erased. It's empty. Did she have anybody she was hanging out with? Anyways, that's another talk for another day. But really, Lori just seems to believe that people should just kiss her every little footstep she takes and treat her like, well, the way she wants to be treated. So not as a criminal that she is. I have to say, out of all the stories I've done and everything that I've seen so far, this is probably one of the coldest, manipulative people on the earth. But I don't think this judge was falling for any of it. And this is how this goes.
Thank you. I've considered the written motion and the response, and certainly your comments today from both sides. Ms. Daybell, I find that the fact that you disagree with Judge Boreski's substantive legal rulings is not a valid basis under Rule 10.1 to grant your motion and give you a new judge. The standard in 10.1 is, has he demonstrated he can't be fair and impartial? And the fact that his rulings have not gone your way is not a valid basis to suggest that he can't be fair and impartial, unless there's some other allegation of bias that's been demonstrated. I don't find on this record that it has been demonstrated. I certainly understand your frustration with the way that the rulings have come out, and it sounds like the way that they came out with prior counsel. But the things that you have cycled through at length in your motion to disqualify, I've considered all of them. Whether or not he should have ruled differently, for example, the example you gave with the juror, or with making findings of fact and conclusions of law in writing, some of the issues you have, if you have concerns about his substantive legal rulings, you can file a motion to reconsider, or you can take them up on appeal. You can file a special action. You have a number of legal remedies at your disposal where you can make those arguments, but they're not grounds under Rule 10.1 to get a new judge. So I am going to deny your motion. Again, as for your concern about his substantive legal rulings, you can address those concerns in a different way, but it would not be under a 10.1. And on this record, I don't find that he's demonstrated that he can't be fair and that he can't be impartial. I also wanted to address the comment that he made, that you illustrated. That comment alone doesn't demonstrate that he can't be fair and impartial. I'm not exactly sure of the context where he made it, but it sounds like he let you ask a question with regards to religion, and that was his decision. But again, I don't think even that demonstrates that he can't be fair or impartial in this case. All right, so I'm denying the request to disqualify Judge Boreski under Rule 10.1. Is there anything else from the state?
No, Your Honor.
Anything else, Ms. Daybell?
Nope.
Thank you, we are adjourned.
So you could hear Lori say, nope, I have nothing more to say. She's not happy about the outcome. And it wasn't too long after this, she had to face that judge she was trying to recuse so badly. Talk about awkward. So can you imagine having to face this judge and then act like none of this has ever happened? And that's exactly what she did. So after she had sat there and been so hateful to the people in the court who had actually gone out of their way to try to help her out, giving her tips when she's pro se, it seems that they become even more helpful after that to Lori Vallow. And watching this, hearing, this is basically all you hear.
Against mitigation at your sentencing.
And isn't that normally put together with the guilt phase? Like they would have that on the back page where it says the aggravators and the guilt?
No.
So are we going to have a whole nother aggravator phase in this case?
If the jury finds you guilty of the charge and the state wants to proceed with aggravators, yes.
And so we do not have to have a hearing to determine if there's probable cause for these aggravators?
No.
They're just alleged aggravators.
Correct.
And the grand jury never found probable cause for them.
Correct.
So you're saying that if the guilt phase goes through and they find you guilty, then you have an aggravator phase added to that.
That's what I said.
So this is what I noticed. As long as that judge doesn't continue to argue a point that doesn't make sense and doesn't talk to her in baby talk, she's fine. But the minute he starts to try to shut it down because she's not getting it. He's trying his best to show that she's not making any points whatsoever, not embarrassing her, but she keeps pushing. He's given her an overwhelming amount of time and chances to avoid making a fool of herself. And she just insists on doing that. I think she believes she's in a classroom. So here you go. Watch the rest of this. You can see she's not happy again with how the judge is handling it, but she just don't get it.
Okay. Hold on 1 second.
You have the allegation of aggravating.
Okay.
It was on my desk.
Your Honor, I would just like it to be on the record clear that the Rule 13.5 that I'm talking about is about non-capital cases.
So here you can see her team's trying to give her some guidance, but not sure if they're doing much better than Lori, because when they address the judge with, their point, the judge just isn't seeing how that's going to work for anything they're trying to achieve.
Well, it says under 13.5a, a defendant may challenge the legal sufficiency of the state's allegations by filing a motion under Rule 16. Is that what you're talking about?
Correct.
It doesn't say you get a probable cause hearing regarding the aggravators. Within the 10 years immediately preceding the date of the offense. This one's really not very specific. Any other factor that is relevant to the defendant's character or background. So, if you were found guilty by a jury of conspiracy to commit first-degree murder, which of these aggravators do you think there's not legal sufficiency for a jury to determine? Because they seem pretty inherent in the charge itself, except for your prior convictions, which, are you saying you don't have the prior convictions within 10 years?
No, I'm not saying that. Which of them don't qualify for the jury to make that determination?
No, you're asking for me to make a determination that there's a legal sufficiency for them to go to the jury.
Correct.
So I'm asking you, if you were found guilty by a jury of the charged offense, which of those aggravators that have been alleged by the state do you think there would not be legal sufficiency for? Because as I look at those aggravators, most of them are inherent in what you're being found. Again, if the jury found you guilty, for example, the first aggravator, it involved the infliction or threatened infliction of serious physical injury. The allegation is someone shot at the victim. That's the threatened infliction of serious physical injury. So it's of a crime. Again, if you were found guilty of the charge, as the state has alleged, the jury would find that a gun was used. So that's a separate aggravator, again, that would already be determined by the evidence. Charged, again, my understanding of the state's allegation is your brother attempted to shoot Mr. Boudreau. You weren't in Arizona. So if the jury found you guilty of this charge, it would mean they found you guilty as an accomplice.
And so the judge really could not please this one. She just went on and on and on.
Okay, if that is the case, then why isn't that found in the original guilt phase as opposed to having a whole nother aggravation phase after that, as if it's a capital offense? Because there's one statute, there's one sentence, there's no arguing the sentence, and if it's already a dangerous crime, then there's no reason to have an aggravator phase.
What do you mean there's no arguing and there's one sentence? I don't understand what you're saying.
There's one sentence for the charge. There's only one sentence for this charge. And if it's already classified as a dangerous charge is what you're telling me, right? Because it's conspiracy to commit first-degree murder. That's a dangerous charge. The jury has already found that it's a dangerous charge. Then what is the aggravator phase finding? If it's already a dangerous charge and there's only one sentence.
Does the state want to respond why the state wants to proceed with aggravators?
To start with, the jury is not going to make a finding of dangerousness as part of the guilt phase per case law. That's not permitted. So the jury has to make a separate independent finding after they find the defendant guilty. The dangerous finding will include the use of a weapon and or the intentional infliction of or threatened infliction of physical injury. So at the very least, the jury has to make a finding as to dangerousness.
I agree about dangerousness. I guess the Question is, why does the state want to prove up aggravators if the jury finds the defendant guilty of the charge as a dangerous offense, given the sentence?
Your Honor, in all honesty, you could ask me this, 10 years ago before Blakely was put out. As case law changes on appeals, I've had to come back before and redo a penalty phase, an aggravation phase, and re-impanel a jury. So I prefer to, since we're already going to have an aggravation phase for the dangerous allegation, to add on the other factors, and therefore I don't have to ever worry about this coming back on appeal later.
All right.
So both the prosecutor and the judge are absolutely aggravated, and rightfully so, because you're dealing with someone, it's like a baby trying to find a reason to keep her finger in the plug, and are trying to explain to her, if you keep doing that, you're gonna get shock. So it's just been very aggravating. We're just all ready for this trial to begin and to be over with, so that those prison doors are shut and we don't ever have to hear her voice again. Just go ahead and start paying for these crimes, the lives you've took, the lives you've destroyed. There's no more lifelines, lady. Let's lock the door. I can just imagine Charles and Joseph Ryan in heaven looking down, saying, shaking their head, now you know how we felt. So did the court give her enough reason to sit back and hush? No.
How is it not already found to be dangerous? You just said that if they find me guilty, then it will be dangerous.
I didn't say that. I said if they find you guilty, then they make a determination whether or not it's dangerous. Now, I think what I meant was when a crime involving a weapon is used, whether it's a gun, usually it's sort of a foregone conclusion that if the jury found you guilty of conspiracy to commit first-degree murder by someone shooting at another individual, that they're 99.9% likely to find that it was a dangerous offense.
When is conspiracy to commit murder not a dangerous crime?
When someone says they're going to choke someone to death and they don't actually do it.
Some instrument may or may not have been used in this crime. It's considered a dangerous crime.
Right.
And these aggravators that talk about something totally different don't have to be found after that it's found a dangerous crime.
Correct.
And that is supported by case law?
Yes.
So that what? When you go to appeal, you can't say it was a non-dangerous crime?
All right. I don't know what to tell you. All right. There was a case that came out about 15 to 20 years ago now called Blakely that said a jury had to determine aggravating factors. Okay. Before that, a judge determined aggravating factors at sentencing. Now a jury has to determine it. The reason it's not done in the guilt phase is we don't want the jury to confuse the issues. We want the jury to decide first whether someone's guilty or not guilty, whether the state has proved its burden beyond a reasonable doubt.
He's explained to Lori multiple times the reasoning. It's not even really affecting now. And he has to sit there and just listen to her go on and on.
So that's why we do the aggravators in a separate hearing. First, you want to make sure the state has proved its burden beyond a reasonable doubt as to your charge.
But these specific aggravators that they allege, right, the ones that you just went over, you're saying that now after you're found guilty of a dangerous crime, that they're going to go back in, and what is the purpose of that? How does it change anything after that?
I don't know how else to explain it to you. So, do you have other issues that you want to bring up today?
Yes, but I would like to finish this first. So are you denying my motion to have a hearing on this?
I'm denying your motion to have a probable cause hearing as to the state's alleged aggravators.
Okay, so you're denying my motion to have a 13.5 hearing on these alleged aggravators?
Correct,
before trial starts.
Because you're not entitled to one.
Okay.
13.5 says that you're entitled to a probable cause hearing if they amend or change the indictment.
This is not an amendment of the indictment?
It's not. There's a difference.
It's an extension of the indictment. It's not in the indictment.
It's a difference, okay, between an aggravator and changing the charge that you're charged with. Changing the charge that you're charged with is an amendment to the indictment. For example, if you were just charged with conspiracy to commit first-degree murder, all right, but the state didn't allege with the grand jury that it was a dangerous offense, you'd be entitled to a probable cause hearing as to that dangerous allegation because it's changing the charge and it's changing the sentence that you would be getting. These aggravators.
That's exactly my point. After the fact, these aggravators, if they're found, what do they do to change the charge or change the sentence or change anything?
Probably nothing in reality. You just said it. They don't change the charge. So you're not entitled to a probable cause hearing. So,
Okay, then I don't want to have an aggravation phase either.
well, you can.
How are you entitled to that? And I'm not entitled to a hearing on probable cause. Then you're entitled to have an aggravation phase.
Well, if you don't want to attend, you don't have to attend. What else?
All right. Something dealing with trial is that I've asked several times for headsets for my advisory council. I know that's been an issue, but you said we can only have 5
So
headsets.
there you go. You got Lori Vallow seems to think that this is some kind of event that's surrounding her, about her, and should cater to her. So I'm hoping to see, the trials started May 29th of 2025, where they started jury selection. One of the key pieces of evidence in this case we're going to see is probably going to be text messages between Lori Vallow Daybell and her brother Alex Cox. These messages allegedly discuss plans to harm Brandon Boudreaux, her nephew-in-law. It's interesting that they haven't decided to bring Chad Daybell in as a conspirator. I guess that's because he's got the worst sentence you can get, which is a death penalty. And right now, I'm waiting to see the witness list. So we know there weren't many witnesses, if any, for Lori Vallow last trial, for Charles Vallow. I think a lot of people were surprised that Summer Shiflett, Lori Vallow's sister, did not show up at the hearing. One of the reasons might be is it could have made Summer look pretty bad if she had, been a witness in that trial, even for the prosecutor. Somehow they were able to eliminate several witnesses that I was really shocked about. So most likely some of the witnesses that we will see here, I don't think we're going to get to see much. I could be wrong, but maybe some neighbors that might testify to the Jeep that they saw when the day Brandon was shot at. Maybe some experts, investigators, maybe his parents. Melanie Boudreaux-Bowaski, do you think she's going to show up as a witness? From some crazy reason, they have been, she managed to stay out of all this mess. She's managed to stay out of jail. In my opinion, she's just as guilty as Lori, Chad, and Alex. Gotta remember, Brandon Boudreaux said that he wanted to forgive people. That's his way of healing and being happy as he moves on in life. Surprisingly, Melanie Boudreaux-Bowaski is even spending time with her children. That, to me, is insane. So what can you expect to see Lori? What will she do for her defense? Probably the same thing she always has, and that is play the victim, point the finger at everyone else, and not take responsibility for her own choices and actions. She'll also continue to poke holes in anything and everything. Just uselessness of pointing fingers at everyone else surrounding her. Love you guys. Share your thoughts. Subscribe, like, and share. See you soon.